This mix carries on the issue of contract law and deals with some of the details left out of the last mix and goes into other aspects of contract law. When considering contracts, courts typically use one of two approaches. A liberal approach where they actually think about what was the intent behind the contract versus a strict approach where they look at the exact wording in the contract including exclusion clauses. Typically, courts will use the strict approach. If a contract is ambiguous, courts will typically select the meaning that works against the party that actually wrote the contract. This is called contra pro referendum. If a written contract exists, then any verbal or other contract or evidence is generally ignored. The written contract holds the truth. If a contract doesn't make sense without assuming that there are terms in it that are implied or implicit, then those implied terms can be relied on. In the last mix, we talked about the concept of equitable estoppel, where contract terms are changed by both parties through their actions or deeds, and then one party tries to reinforce the initial terms in the contract. They can be stopped from doing so. The first case that describes this is Conwest Exploration versus Latane. Conwest had options to mine on Latane's land. They weren't able to explore those options in the time period allowed because of bad weather. They agreed with Latane that they could continue exploring for a slightly extended period, but they did so without changing the contract, without exchanging new money for extending the option. When Conwest wanted to then exercise the right, Latane tried to enforce the original contract, but they were stopped from doing so because this was not fair. Conwest was relying on the gratuitous funds given by Latane. In the second equitable estoppel case, John Burroughs agreed to sell his company to Subsurface Surveys. Subsurface Surveys had a payment plan to pay the shares over a number of terms, and a few of the payments were made late. Burroughs didn't take any direct action when those payments were made late. However, eventually, when a payment was made late, Burroughs decided to enforce the contract terms, which said when the payments had to be made. Subsurface Surveys tried to claim equitable estoppel in this case. But since Burroughs hadn't done anything to show that he was in agreement with the late payments when they'd been made, this inequity wasn't proven. In other words, inaction doesn't mean that Burroughs actually agreed to the change in the contract terms. In the final equitable estoppel case, this occurred between the Owen Sound Public Library Board and a company that was going to do some renovations to the library, Mial Developments. They had a contract which stated how quickly payments were expected to be made between receiving a certificate of completion of some of the work, and if that payment wasn't made, then the developer could terminate the contract subject to a notice period. When the developer requested payment, providing their certificate, the library board requested proof that all of the developer's subcontractors had also been paid. The developer agreed to get that proof, but they didn't then provide any proof in practice. So Owen Sound Public Library didn't pay because they were waiting for the proof of subcontractor payment. The developer gave notice to terminate the contract, and all of this happened over a Christmas break. So Owen Sound paid as soon as they got notice, but the payment turned up slightly late. And so the developer claimed that the contract had been terminated, but the library said that Mial had breached the contract because they had agreed to provide proof that the subcontractors had paid and had never then provided that. So in agreeing to get proof that the subcontractors had been paid, the developer had actually issued a gratuitous promise, and so it was reasonable that O&M didn't pay per the contract terms, because it was reasonable that they understood that they didn't have to pay until they had receipt of that new document. Changing topics, with regards to the legality of purpose cases, typically legality of purpose issues crop up in contracts around the area of non-competition clauses and employment contracts. So when an employer issues an employment contract, they'll often have a clause saying when the employee leaves the company, they cannot work for a competing company for a certain period of time. There are three fundamental principles that have to apply for that non-competition clause to be upheld. The employer does actually have to have a reason for needing a non-competition clause. And that clause has to be reasonable in terms of where the employee can't work and how long they can't work. So for example, saying when you leave employment of this company, you can't work anywhere in Canada for the next 5 years, that would be unreasonable. And there has to be a reason to restrict working for a competitor or competing against the company versus just soliciting the company's customers. The two case precedents that are worth quoting for inequitable contract law are Elsley v. Collins and Lyons v. Multari. In the Elsley v. Collins case, Collins employed Elsley to work with customers, and Elsley had specific knowledge of Collins's customers. After having employed Elsley for a period, Elsley decided to go their own way and work on their own. Collins's contract with Elsley said that Elsley was not allowed to work anywhere in Niagara Falls for 5 years after leaving Collins. Collins had some value. The customer base, the knowledge of the customers was of commercial value to Collins. And the period, whilst long, was constrained to a small area, so it was reasonable that the terms were okay. And because of the privileged knowledge, it wasn't sufficient not just to solicit Collins's customers. Elsley could actually not compete with Collins because that was the risk. In the second case, Lyons v. Multari, this involved a couple of dentists where the one senior dentist hired a more junior dentist who eventually decided to set up their own practice. The terms of the non-competition clause were reasonable. However, there wasn't really any direct competitive advantage that one dentist had over another. It would have been sufficient to say, don't solicit each other's customers, therefore the case was not successful. With regard to misrepresentation, you have to, as we discussed in the last mix, prove for deceit or fraud that a defendant knows that what they are saying is untrue, or that they really don't believe it's true, or they are really being reckless when they consider whether it's true or false. And the case that really defined this was Dairy versus Pig at the turn of the last century, when the director of a tramway company wanted to go from using horse-drawn trams to using steam trams. They believed that they would be able to make this change, but the Board of Trade actually blocked permission, even though nominally this should have been a trivial thing to obtain. So the shareholders of the tramway sued the company for damages where they weren't able to change from horse-drawn to steam trams. It was proven in this case that there was no deceit, there was an honest belief that the permission would be authorized. So therefore, there wasn't fraudulent or deceitful misrepresentation in what David claimed.